Back in 2008, when Obama was president, the U.S. government really cracked down on Swiss banks. Switzerland came up with a deal that said, all right, our banks will report to the IRS. And they actually changed their business model to cater to Americans.
Why wouldn't somebody getting ready to go through a divorce just throw everything offshore and say, look, I got nothing?
They do that.
Is there any country that you can put money anonymously? What it is, Brad Lee back again with another episode of Dropping Bombs. Today in the studio, folks, I got a real treat for you, especially if you got a little dough you're looking to protect or some assets you're looking to protect. Folks, I have attorney Blake Harris in the chair today. Welcome, Blake.
What it is, Brad. It's an honor to be here. Let's talk about how to protect some money and wherever else this conversation takes us.
Dude, I like the jacket.
Thank you very much.
Is that like Versace?
It is like Versace, but it's not Versace. Picked it up in Miami Beach a few weeks ago, and I figured if I'm coming on prestigious podcast like this, I wouldn't mind getting remembered. So
it's a good looking jacket.
Between podcast, my social media, conferences, and just walking through the airport, it stands out a little bit.
Well, it does, and it's a good looking jacket. Sometimes I think people try too hard and it's like they didn't do the right job. But dude, the shirt, Matt, everything's right on, dude. Good job. Good job on that jacket.
And I don't wear the suit and the tie. Did that when I started out my career and I didn't know what I was talking about. But as I got comfortable with what I was saying, I've become more comfortable in how I dress. And I find that this actually helps to disarm clients. And they're much more willing to share and open up with me if I'm not all stuffy. So
do you deal with a lot of rich people only or all kinds of people?
I mean, I definitely work with some very wealthy people, but interestingly enough, the majority of people setting up international asset protection structures are not what most people would consider super rich. They have a net worth generally somewhere between about $1 to $2 million and about $10 to $20 million. We do have some clients whose net worth is a little bit under $1 million, and we do have some clients whose net worth is well beyond $20 million. But the majority of people who need asset protection are not super wealthy. They are the ones who have their own business. They're the ones who are concerned about their family wealth. And if an individual worth $100 million gets hit with a $5 million lawsuit, they can pay that judgment and move on. It's not going to have any real effect on their standard of living or quality of life. But if somebody worth $3.5 million gets hit with a $5 million judgment, they're going to need to negotiate. And nothing's going to be better for their settlement leverage than having their assets already protected.
How long does it take to protect your assets?
So it takes about 30 days to get the trust established. Now, if the clients are being very responsive, we can expedite the process, but generally it takes about 30 days between the back and forth with the client and the trust company and getting everything drawn up and registered. And then it takes another about 30 days to get a bank account open under the trust. So in total, about 60 days. And again, if clients are being responsive, we can expedite that process.
Do you have to put all your money over there?
No, you don't have to make full use of the trust. I generally encourage clients who have assets that are not protected to put those into the trust. If you have a home in, let's say, Florida or Texas, that's already a protected asset. If you have a retirement account with under $1 million, chances are that's already protected as well. So you don't need to put a protected asset into your asset protection trust. But some clients will fund their trust a little bit over time. They want to get more comfortable with the international banks and their trust company. They don't want to put everything in right away. And that's fine, but you don't get the benefit of the protection until you've actually put the assets in the trust. So no, you don't have to put it in right away, but we generally advise clients to put yourself in the best possible position as soon as possible. And if you want to take money out over time, you can.
So international asset protection, which basically means offshore.
Correct. So
accounts.
In the world of asset protection, you have two options. You have domestic trust and you have offshore trust. And I'm going to break it down for you very easy, Brad. One of those styles can be broken by a U.S. court. The other cannot. And you're going to get much better results when you have a plan which will hold up to pressure from a U.S. court order.
Which I assume, is the international asset protection.
You're not just handsome. You're smart as well, Brad.
So the domestics aren't as strong.
So domestics are not as strong. They will cost you a little bit less to set up, But where you save money in the setup process, you are losing out many times over in the settlement. So you may save $5,000, $10,000 by using a domestic trust as opposed to an offshore trust, but that could cost you hundreds of thousands of dollars in settlement leverage down the road, because a plaintiff attorney is going to figure out quite quickly that if they push hard enough, and the case law supports this, there's a good chance that they're going to be able to break into your Nevada trust or your Wyoming trust or your Delaware trust. On the other hand, if they push hard against an offshore trust, well, for one, they're not going to be able to push against it at all, because you need an attorney who can practice in the Cook Islands or Nevis or another country you do business in. And even if they found an attorney there to go litigate, their chances of success are so small that it doesn't make sense economically almost ever to try to break into an offshore trust.
Because of what?
Why is it hard to break into an offshore trust?
Why does it not make it worthwhile?
Why is it not economical to go after an offshore trust?
Yeah.
Because the cost to do it is going to require you to post a bond of maybe $100,000 or more. You're going to have to hire legal counsel in another country. In the United States, if you want to bring a lawsuit, in most circumstances, you can bring in a contingency fee. You don't have to put any money up front. In the Cook Islands, contingency fees are illegal. You have to pay up front. You also have a much higher burden of proof. In the United States, for a civil matter, you have to win your case by what's called a preponderance of the evidence. So it's 51% to 49%. In the Cook Islands, to win your case, they have a much higher standard, that which we use in the United States only for criminal matters, and that's a standard of beyond reasonable doubt. So even if 50, 60, 70, 80, 90% chance that the plaintiff is right, that's not going to be enough to win the Cook Islands. You have to win by a standard basically 99.9% chance. It is very hard to meet that burden of proof. On top of that, you can't even amend a case in the Cook Islands. So if you've started a case in the United States, you dig into someone's personal affairs, you've done discovery, you've taken depositions, you've made them spend money, you've wasted their time, you can amend the case and just keep moving forward. Cook Islands, you cannot amend a case. You have to drop your case, start a brand new case, at which point, if the statute of limitations hadn't already run, it has probably run at this point in time. Most plaintiff attorneys think money, and they think instead of spending all of these resources for a case where you may not even win in the Cook Islands, it's just easier to take a settlement and move on to the next target.
So out of curiosity, what if, somebody puts all their assets over there and they get sued and they are guilty? Or is it still more than likely protected?
So, well, that's the whole point. If they are found liable, what happens? The court's going to say, what assets do you have? And there's a common misconception of, I'm going to hide my assets. I'm going to bury them in the backyard. I'm going to give them to a friend. After a judgment is entered against you, a court can order you to complete a debtor's exam where you have to disclose your assets, including any assets that you've given away in the past 3, 5, 7 years. This would include mentioning that you do have the trust. However, disclosure of the trust in no ways compromises protection. So let's say next step, the court says, okay, well, the only real asset you have is this $2 million brokerage account that's in a Swiss bank owned by a Cook Islands trust. Bring that back. If the court orders you to do something, 100% of the time we tell our clients, comply with the court order. However, the trustee who sits outside of the United States, by law, is not going to follow any U.S. court order, and they're not going to follow any request that you make while you are acting under court order. So in general, if you want money out of the trustee will send it to you. But if you're making a request while you're acting under duress, the trustee withholds that distribution.
Is there any danger in losing your money to that offshore trustee?
This is a question that I get asked by every single potential client, and it's a very good question. Not if you work with the right trustees, not if you work with the right banks. My firm, we only work with the most reputable in the industry. The companies we've been working with have been in business for decades. They manage billions of dollars in assets, and I maintain a very close relationship with everyone we work with. Every single year, I go to Nevis, I visit the Cook Islands frequently, I visit Belize frequently as well. I know the owners of these companies, the managers, the frontline employees. These are very good jobs in the countries that we do business in, and they are very concerned about their reputation. The last thing they want is anybody in that country to mismanage funds. In my experience, not just my experience, but as a matter of fact, the trust companies in the Cook Islands are better supervised than U.S.-based trust companies. In my experience, the service has been even better as well, because this is a vital part of their economy. There's lots of ways that people can make money in Nevada. It's not just the trust industry. In some of these countries we do business, offshore asset protection is vital to their economy.
Do you have them?
Do I have an offshore trust? I wouldn't be selling Mercedes, not driving around in one. Yes, I have a Cook Islands trust and I have an offshore bank account.
So when I was filling out something, I forget what it was, might have been taxes. I don't know. It said, do you have any offshore accounts?
Yes. So when you fill out your taxes, they ask, do you have any money in an offshore account? And you do have to report the trust. Now, the trust in no ways increases your tax liability. It doesn't decrease your taxes. I get asked often, oh, can I set up an offshore trust to avoid taxes? In which case I say I wouldn't be living in Miami. I'd own Miami if I could avoid income taxes. So yes, we give our clients a detailed memorandum on how to complete all the reporting requirements, Form 3520, 3520A, the FBAR. If you have an account offshore, you have to fill out an FBAR if there's more than $10,000 in that account. It doesn't increase your chance of an audit. You just need to properly report it. The IRS sees it as an act of compliance, and in no way do they penalize you for having an offshore trust. You just need to report it.
Yeah, I saw the question, but I don't.
Yes.
So I'm like, no.
But don't announce that on your podcast because you're advertising that you're a target here, Brad.
Well, I have trust. They're just not offshore.
Okay.
And I was always told, which apparently must not be the truth, that I don't own the trust. So when someone says, it's not my asset.
Okay, so, well, I need to dig in a little bit farther. If the trust is set up where there's a beneficiary other than you, let's say you've set it up for your children and it's been 5+ years, that's an asset that you've given away and it's legitimately not yours. Now, if you set it up as a self-settled trust where you're the beneficiary of the trust yourself, then the court may look at that and say, well, that's your asset. And although you've set it up under Nevada law and you're here in Nevada, we have a creditor from California, and under Article 4, Section 3 of the U.S. Constitution, every state must give full faith and credit to the judgments and court orders of every other state, and that could be used as a means to pierce your trust. It is better, in my opinion, to have a domestic trust than do nothing, but when it comes time to actually using it, you're going to have much more settlement leverage, negotiation power if it is controlled by a foreign trustee than a trustee who is going to comply with the U.S. court order.
I had someone in here not too long ago. They claimed if you have certain kinds of trusts, they weren't talking offshore, they were talking domestic. I believe a charitable trust, a business trust, and a family trust all set up somehow, some way, then you ultimately don't own anything. Your trusts own everything, and you're just the trustee of the trust.
Well, for a charitable trust, I would generally agree with that. This is money that you've given away to charity. It's no longer an asset that you can take, even if you're acting as a manager of that charity, as a trustee of that trust. I would agree with that. With the family trust, as I mentioned, if it's other family members as beneficiaries and sufficient time has passed, I would say that's not your asset as well. But if it's a trust that's set up for your benefit where you still have access to the money, a U.S. court is probably going to say, Brad, that's still your money and you need to hand it over.
I thought because it's the trust, it's not my money. It's the trust's money. I'm just a trustee.
Well, so here,
I don't own it. They own it. The trust owns it.
Okay, so with a trust, you need to understand how ownership works. Ownership with a trust is different than ownership that an individual has of an asset. With a trust, there's two owners. There's the controlling owner and the beneficial owner. So the controlling owner is going to be the trustee. And if that's still you, that doesn't really give you the ability to, it gives you the power to, but not the right to give that money away.
Right.
If you are still the beneficiary of the trust, case law supports that asset could still be compromised. So for the trust that you've set up, if you're still the trustee, that may be okay if you're not the beneficiary. If you're still the beneficiary and you're the trustee, there's a good probability a court's going to say, Brad, that is effectively still your asset and it should be used and available to pay a creditor of yours.
Now, what if I thought I was being smart? So I set up a trust. I'm not the beneficiary. Let's say my son is, and I'm just the trustee permanently until I die. And then my son gets sued somehow.
Third-party trusts are quite well protected. I will throw a little caveat out there that it's probably not the best situation where if you're setting up the trust for you to still be the trustee, maybe your wife or someone else could be the trustee for your son, or if you have multiple children, let your children be the trustee of each other's trust. But if your son is the beneficiary, no, that's pretty good. The case law, the way the legal system sees that is, well, it's never your son's money in the first place, so it's not his to give away to a creditor. So that type of trust is okay. The type of protection that you can give your children when you die or when you give your money to them is very similar to the type of protection that you give yourself when you set up an offshore trust. So if you're setting up a trust for asset protection purposes and you want to be the beneficiary of that money, you want to enjoy that protection while you're alive, it'd be very advisable to go offshore. But if you want your children to have that protection, you could do that with a revocable trust that you could download from LegalZoom for $100, or at least a local estate planning attorney could draw it up properly for a few $1,000s.
What are the trusts that do allow you to eliminate and or drastically reduce tax liability? Okay,
so first of all, tax liability only applies to a small portion of the population. You need to have what's an estate that's worth more than about $13 million as an individual, or as a married couple, more than $26 million. If your estate is under that threshold, you don't have really any estate tax liability. That may change, but that's where the exemptions are now. If you have more than that amount, then there are various types of trust available that can be used to reduce your estate tax exposure. The most common one, the first one that would be recommended, is probably going to be an ILIT, ILIT, standing for Irrevocable Life Insurance Trust. You've got a life insurance policy that maybe is worth $1 million now, but when you die, it's going to pay out $10 million. That's a great gift to gift away now, so it only eats up $1 million of your estate tax exemption, and then when you die, $10 million passes estate tax free to your beneficiaries. The same is true as if you've got interest in a company that's about to go public. You know that those shares are probably going to be worth a lot more. That's another great one to gift away. It's very much a tool. The trick to reducing estate tax, I say, it's very much about timing. Assets which you believe are going to appreciate in value are great ones to give away, and try to avoid estate tax that way.
Do you help people with this, or just strictly offshore?
So my firm focuses on the asset protection component. We don't get into the tax planning side of it. If a client of ours has a net worth that does put them into a taxable bracket for estate tax planning, we're more than happy to introduce them to another attorney outside of our firm who can mitigate estate tax.
I almost want an attorney that can, vet another attorney.
Well,
and then it's almost like, when you sign your tax returns from the CPA, it's like, why would I have to sign anything if the CPA said that they're right?
I agree with that. The attorneys that we work with, and I do take a lot of pride in the network that I have built. I don't believe there's another attorney in my industry, in the offshore asset protection industry, that has a global Rolodex anywhere close to what I have built up and what my firm has built up. In terms of the attorneys we work with, if we refer someone, we don't take a referral fee. We're not interested in finding people who help our clients that give us a kickback. We're interested in finding people who just do the best job for our clients, and therefore make us look good.
That's good. Well, the reason why is because, again, this guy, and he's not an attorney, but he sets up trusts for people. And his claims are, go look up the IRS code. It says right here, and read that yourself, and go do your own homework. And if you do this, you literally can legally not pay taxes, or very many of them, no matter what you're making. And I'm like, dude, this cannot be real. And he's like, dude, the wealthy get away with it all the time. And here's how they do it. They go bing, bing, bang, boom. And I'm like, okay, sounds good, but there's a lot of people in prison right now that did that or something like that. And then they found out that whoever sold them that bill of goods was full of shit. How do we know when lawyers are full of shit or not?
That is a good question. And that's something that it would be great if you could detect quickly. There's a few ways to look at it. One is if it does not sound right, if it sounds too good to be true, if it sounds sus and someone's telling you that you're going to be able to eliminate all of your income taxes, I'd be a little bit concerned there. Also, look into the attorney's credentials. Have they taught continuing?
He's not an attorney.
He's not even an attorney, or other.
He has attorneys.
Other credentials. I would do a Google search on that person and see what you pull up. I would also recommend, if you are doing preparation of legal work, it would be wise to work with an attorney. I would also want to make sure that their claims are backed up. Before we started recording, I told you that I've been told that my law firm for the past several years, I've been told by the leading Cook Island trust company that my law firm has registered more trust with them than any other law firm in the world. And we have this on video and it's on my social media accounts as well. I don't say that we've done this. I say we've been told because there's third-party verification there as well.
Well, let's get back to that because that's what I'm interested in anyway. Just sounds cool. Offshore.
I think so. I mean, I say there's several reasons to set up an offshore trust. It protects your money from lawsuits, it gives you access to more investment, and it makes you cool like James Bond.
That's right.
Yeah.
It's like, you don't have any offshore accounts, buddy. What are you doing?
Yeah.
You're not at our level yet.
Exactly.
So what does it require to open up an offshore account and a trust? What does it require?
Okay. Well, let's talk fees. To set up an offshore trust, it's going to generally run you somewhere between about $20,000 and $40,000.
Okay.
The lowest I've heard of anyone selling an offshore trust for is maybe around $10,000. And when you work with some very high net worth individuals who may have some tax issues as well, it can get up to $100,000, $200,000.
Because they're taking advantage of you?
I'm not going to say that they're taking advantage of you, but if you are pull up to certain places driving a Rolls Royce, you may be quoted a different price.
Or if you're in a situation.
Well, that's the other issue. If there's pending litigation, if there's heat, if you've got a situation where most attorneys won't work with you, where it's going to take a lot more time negotiating in conjunction with your defense counsel, if you are a celebrity or a high-profile person and the trust companies are going to be reluctant to work with you, yes, there's extra headache.
Why would they be reluctant?
These trust companies are very worried about their reputation. And if somebody gets into trouble, but they're not going to get a lot of media attention, it doesn't cause any pushback in the Cook Islands or Nevis. If it is somebody who has a big podcast and a big following, and even if they do something small, that's still going to cause ripples and cause the regulators to get upset at these trust companies, then that would be a client that they're going to be more apprehensive to take. On top of that, banks are the same way. If somebody is a celebrity, but the celebrity's done some controversial things along the way, the banks are going to be more reluctant. I take great pride in that when I get a call from somebody who is a celebrity or semi-celebrity, and maybe they've run into some hiccups, that if it is possible to get a trust set up for them and a bank account set up for them, I'm confident that my firm can do it. If it's possible, I don't believe there's anybody better than our firm that has the ability to get them protected.
And folks, if you guys are already going, man, this guy's like a freaking, genius. Well, you already know where to find him. BlakeHarrisLaw.com. And by the way, if you go to @BlakeHarrisLaw, any social media, you'll find him. You'll probably see the jacket. But I'm interested to know, other than if you get sued, you're protected, what other benefits are there? Because I don't get sued, and knock on wood, I'm not going to. So why would I do it?
Well, if you know that you're not going to get sued, then you probably don't need an offshore trust.
So it's 100% in case you get sued.
There's other benefits as well. It avoids probate, but you can do that with a regular revocable trust. It avoids in places where there's forced heirship laws. You can't disinherit your children. We can get around that.
You can't disinherit.
It's not so much an issue for Americans. I think Louisiana may have maybe the only state that requires you to leave money to your children. Any other state, you can disinherit your children. Certain states have an elective share where you have to leave certain money to your spouse. You can get around that. Certain companies won't take investments directly from Americans, but if it's through an offshore trust, it gives you the ability to access. So it's increased investments, it's asset protection, it's avoiding probate, and it's avoiding forced heirship laws. Those are the main reasons, but overwhelmingly, it's asset protection, the peace of mind that comes with that.
What about if you're married and your wife is not your friend? And you plan on divorcing, but you want to move assets, doesn't your wife have to sign off on shit?
No. If the assets are in your name alone, you have the ability to rearrange your financial affairs however you see fit.
So why wouldn't somebody getting ready to go through a divorce just throw everything offshore and say, look, I got nothing? They
do that.
And it's legal?
And it's legal. If you do it before the divorce gets filed, then you can set up an offshore trust. And I still recommend in the situation of divorce that you make some settlement offer, but don't get taken advantage of.
Well, sure, but does that put you in the driver's seat?
Oh, very much so. I mean, if you've got the bat and the ball in your trunk, you're in a much better position than if you are negotiating against somebody who's already frozen your accounts.
So let's say I've set up an offshore account. I've set up an offshore trust, but I haven't put much in it. I drop $100,000 over there.
Mm-hmm.
And now I'm living. And my girl gets lippy. And she's like, hey, asshole, I'm leaving you. Before she files anything, couldn't you just go blip and transfer everything over there? Or is there a big process to do that?
So it's not unusual for a married couple to have fights along the way. I mean, couples stay together for a very long time and have these tough fights. And it's hard to say when the marriage really went in separate directions until something got filed. Now, in the situation where you don't want to put everything offshore, we would still advise clients to keep money under the umbrella of the trust in a U.S. bank account. It's better if the money's offshore because the U.S. court can't touch it. But if you have it in a bank account here in the United States and something later arises, the trustee can be the one to move the money from a domestic account to an offshore account. That way, in the middle of the heat, you're not the one moving anything around. It's the trustee. The transfer you made was months or years ago.
You guys got it all figured out, don't you, Blake?
And is it even ethical to do this? Well, let me tell you something, Brad. I don't believe this ideal that being weak is honorable, that being unprotected is wise and good for you or good for your family. I think just the opposite. I think the stronger you can make yourself, the better you are able to provide for your family, the better you're able to resist evil, the better you are able to protect yourself. Freedom does not exist without protection. And this is very much what I believe my firm is doing. We are protecting freedom here in America.
I like it.
Or did I just drop a bomb?
No, I did.
Okay.
On what you said. So this is interesting because I just get into my listeners' heads and I'm thinking all the things I would be thinking if I were just listening to this. You know, I'm thinking, number one, what do I want one of those for? Number two, like, what if I call up the trustee took my shit and ran, and who do I call now? And you're gone, and whoever set it up for me is not answering the phone, and I just got swindled. That's number one. Number two, well, why wouldn't I set one up in case I don't want anybody taking my shit from a divorce? Like, boom, I'd throw it over there for that. But with that mindset, why wouldn't you put everything over there and own nothing here? Can't you control it from over here?
Absolutely.
Can't you write checks and use credit cards and have it all paid from the offshore?
Okay, so a few different things you threw in my direction. Let me just take a few pieces at a time. In terms of control, you can always control it. You tell the trustee how you want the money invested. You tell the trustee when to give you a distribution. And again, aside from the situation where you are acting under court order, you're going to be able to control it. You're going to be able to get distributions. In terms of credit card, you can continue to live off your credit card and your trustee can pay your credit card bill every month. If there's no pending litigation, generally we'll have clients keep a domestic account with about 6 months to a year worth of living expenses, and then they can use that to pay their credit card. But if they're in a position where we don't want them to have any money that somebody could take, we'll just have them live off their credit card. The trustee can pay the credit card bill. The trustee can pay for the children's education. They can pay for the mortgage. They can lease a car for the client as well. In terms of why not do it to keep yourself protected from a lawsuit or divorce? Well, you're preaching to the choir here. It's definitely the best possible tool for that. And in terms of who to work with, there is an element of trust when you create a trust. Just as a domestic trustee, and here I'll step back. In my career, I've only heard of one time where a professional trustee stole the money. This was not to a client of mine. That was a trustee out of Chicago. We've never had this issue with any of the offshore providers. But you do want to work with an attorney who is well ingrained in this area and keeps close relationship with the offshore trust companies. Where there's more of an issue is sometimes there's a response time. Some trust companies are more responsive. Some operate still on island time. And that can be a little bit frustrating, though they still get the job done. So working with a trustee who gives you confidence, and you should be allowed to talk to your trustee. You should be able to look up the trust company. Your trustee, once you've hired them, will get on a Zoom call with you. They come and visit America from time to time. It's very important that they are building these relationships. And it's important that the legal team here travels and meets with the team there, because there's just a special bond that you get with the person. And it allows us, my law firm, to, in part because of the quantity of work we do, get better deals for our clients. We've negotiated deep discounts for our clients with a lot of our offshore providers, and we pass these on to our clients as well.
Who appoints the trustee?
Who appoints the trustee? So to your question of what do we do with so who appoints the trustee? At the time the trust is created, the client will. Now we have trustees that we recommend in the different jurisdictions we work in, but the client is ultimately the one naming the trustee, and the trustee agrees to serve as trustee. Then the client serves as the beneficiary. In addition, there's one more person at the party called a protector. The protector has a very limited role, and the protector is the one who has the ability to fire the foreign trustee and appoint a new trustee. So if we want to move the trust back to the United States, or if we want to move it from Belize to Nevis, the protector is a third party that has the ability to fire the trustee and appoint a new one. We would do this if, number one, the trustee was ever not complying with what we wanted, but we've never had that issue. And if we did, we'd stop working with the trust company, and we would tell the other people who refer business to the trust company to stop working with them, and the trust company would probably be out of business very quickly. But if for whatever reason we're not happy with the new manager of the trust company or something like that, we can change to a different trust company. If litigation commences in the Cook Islands and we don't think it's going to be a favorable outcome, we can move the trust to another location, make them post another $100,000 bond in Nevis and start their case there. Sooner or later, a plaintiff is going to realize, I'm going to continue to spend money chasing this defendant all around the world, and I may never get anything. My only hope of getting anything is going back to the negotiation table.
The protector, who is that?
So it's a third party that their sole job is to serve as protector. And the company, and we work with a few different protectors. We work with protectors in Nevis, Belize, New Zealand, Angola. And it's a company whose sole job is to serve as protector. Again, we keep close relationships with all these people.
Would you say Elon Musk has offshore accounts?
So a common question that I get is, do all super celebrities have an offshore account? Do all politicians? And the answer is absolutely not. Lots of very wealthy, successful people are very sloppy in their estate planning and asset protection planning. A lot of them do, but I would say that there's plenty of very high-end people who have no or lack an asset protection. What will happen though is it'll be one person on a NBA basketball team that gets targeted with some type of lawsuit. I'll let you guess or come up with your own imagination what that might be. And then the rest of the team gets a wake-up call. Or one of the doctors at a hospital gets sued when they didn't do anything wrong for a patient. And then every other doctor at that hospital starts looking for asset protection. What was your question again?
Do all celebrities have it?
The question was Elon Musk. As to Elon Musk, I would be very surprised if Elon Musk did not have bank accounts in lots of different places. I'm sure he has assets stored away in lots of different places. He would have some trouble setting up an offshore trust, though he could form his own country if he wanted for asset protection, just because of what I said about high-end celebrities, trust companies being a little bit more reluctant, banks being a little bit more reluctant. But it's also a weighing factor of how much money you have. And when you have unlimited money, banks are probably more willing to consider someone even like Elon Musk.
Because they get the float while it's sitting there?
Because bankers like money.
Yeah.
And this brings me back to another point, which is a common question I get, which is, can Americans actually open a Swiss bank account? Back in 2008, when Obama was president, the U.S. government really cracked down on Swiss banks that were not reporting U.S. bank accounts, U.S.-owned bank accounts to the U.S. government. And Switzerland came up with a deal that said, all right, our banks which hold American funds will report to the IRS. And a lot of Swiss banks said, well, we don't want to have to bend over to the IRS. We're going to stop working with Americans. A lot of other banks in Switzerland said, well, we bankers, we like money. And you know what Americans have a lot of? that money stuff. And they actually changed their business model to cater to Americans. And there's a whole group of bankers and investment advisors in Switzerland who cater to the American market. And they work with banks which are very safe. An American bank might keep 5 to 10% of its cash on hand. Some of these Swiss banks keep 15 to 40% of cash on hand. They don't allow outside investors who pressure management to take risky bets. They don't get involved in investment banking or prop trading. It's overall just a much safer place to bank your money than probably anywhere else in the world for an American.
What are the downsides of doing it?
Well, you got to pay my fee for one. Other than that, the reason people criticize offshore trusts is because you have to report it to the IRS. As I mentioned, we give our clients a memo on how to complete the IRS and FinCEN reporting requirements. And then beyond that, you don't get to stay up all night worrying about losing your money.
And the main reason you would lose it is if you got in a car crash and hurt somebody, or you're getting a divorce, or you somehow get sued in some way.
Both of those are very common. Also business disputes. Former employees, it's very easy for them to exaggerate or fabricate a claim and squeeze out a settlement. And what happens often is somebody gets sued even though they've done nothing wrong, but they find out how much it costs to defend the case, how much it costs in terms of time, how much it's stressing them out. And they decide, you know what, I'm just going to pay a settlement even though this is a complete BS claim. And what ends up happening is wealthy people end up becoming victims of what I refer to as legal extortion. And we don't want that to happen to us or our clients.
Hit and runs.
Hit and runs, or someone slams on the brakes in front of you, or for whatever reason,
or you break a jar of pizza sauce on the floor and slip on it. You don't do business with paper. We draw up these contracts, attorneys. You're doing business with people, and no matter what paper you have between you and another person, if the other person is a psychopath, that paper is not going to stop them from coming after you and making your life unpleasant. Can businesses be transferred with partnerships?
So a offshore trust can hold pretty much any type of business entity aside from an S corp. In very limited places, an S corp may be able to go into the trust, but for simplicity, for the millions of people listening to the podcast, let's just say S corps do not go into the trust, but otherwise partnership interest, a membership in an LLC, real estate can go directly into a trust, shares of a C corp can go into a trust, crypto can go into a trust, gold and silver, just about any asset that you can own can be owned by a trust.
Do you need one trust for all assets because it's offshore, or do you need, like, if I own 50 houses, I need 50 trusts?
So it is not based on the number of houses you have. You would want those houses generally owned by an LLC. I don't necessarily recommend a separate LLC for every single house, because while each LLC does segregate the liability a little bit more, it causes additional headache. There's more books you have to keep, and there's more filings you have to deal with for 50 LLCs. But let's say you got 50 houses and you put them into 5 LLCs. Those 5 LLCs can all be owned by one offshore trust. If a client's net worth is under $25 to $50 million, we'll generally only recommend one offshore trust. If their net worth is above $50 million and there's so much money in their trust that a plaintiff may decide it's worthwhile to go and try to litigate this overseas, that's when we may be recommending a second or third trust. But for 99% of our clients, one trust is all they need.
And usually if they're going to recommend litigating overseas, it's because they're sure they're winning that one.
They're sure they're winning, or maybe there's some personal issue there where the person just wants to make the defendant's life as hard as possible. And even though rationally it may not make sense to go after it, there's something else that are motivating them to go after the defendant. Most plaintiffs and most plaintiff attorneys are rationally minded, and they're looking for a payday. They're not looking for revenge.
Well, if someone were to bring up a suit against you and you have an offshore trust and they did agree that they're going over there to knock you out, now, wouldn't you have to also go there and defend yourself?
You would hire an attorney there. You don't have to physically go to the Cook Islands yourself.
But that would cost you more than here, no?
It would cost you comparable to here. Yes, you'd have to hire an attorney and fight the battle over there, correct? But again, the odds are in your favor because beyond a reasonable doubt standard, we've eliminated contingency fees. We've required them to post a bond.
No amendments.
Exactly. So
it's better over there.
So yes, at least home court advantage.
I thought the trust owns everything. So if someone sued me, well, I don't own that shit. The trust does. How can they sue the trust?
So you would have to, on a financial affidavit, report that the trust exists, but you would state the value of the trust at $0 because you're a discretionary beneficiary. Now, if the plaintiff digs deeper, they can find out what assets are in the trust. They can get your tax returns from last year and see that you've transferred $1 million into your Swiss brokerage account owned by your trust. If they want to go after it, they can, but it's going to be a very uphill battle. Even though you're a discretionary beneficiary, a plaintiff could use that as an angle to try to go after the trust.
And this takes more conversation, obviously, than a podcast, but I'm getting a lot of info here, and I'm sure a lot of people are too. And again, folks, if you guys want to look further into this for yourself, BlakeHarrisLaw.com, or just hit him on the DMs at BlakeHarrisLaw on any social media. Is that right?
That's right. Our DMs.
So an average Joe that's not really crushing it in life, but they're doing, $300,000 a year. They're starting to, make some investments. They're starting to buy some real estate. Is it wise to get it set up now? Because 20 to 40 grand is a considerable chunk when you're making, 200-300. Is it worth doing?
So it is an investment, and when is the right time to do it? It depends on several factors. Now, if you're making $300,000 a year, but you're spending $300,000 a year,
which is most people,
and you're not for the first few $100,000, it tends to come and go pretty quickly, and you're not accumulating any assets. Well, you don't really have any assets for someone to take. I would say maybe start a retirement account, so some of that money siphons off into an IRA or a 401k. That money is protected. But if you're not saving any money, then no, you don't need asset protection. But once you notice your savings are $500,000 and you believe your savings are going to grow from there, then that's a good time to look at asset protection, especially if you are in a high-risk position, whether that's because you have children driving your car or because you're a social media influencer and there's millions of people listening to your video content who may take some advice and then decide you should not have recommended Bitcoin, or it's because you run your own business. And although you may run average Joe plumbing, you've got $500,000 in assets, and it's not unlikely that one of your employees may hurt somebody in their truck or may upset a customer along the way. Treat people well. That right there is going to save you a lot of problems. Simply letting your customers know that you care about them is going to stop a lot of lawsuits. Try to settle things quickly, but no matter how careful you are, if you are successful enough in the United States, you can't expect to be sued at some point.
Yeah, so let's say somebody, has equity in companies, maybe some crypto, money, but it's in the company's accounts, not a lot in their own personal accounts, and maybe a house or two, but not a lot of equity in those houses. But it collectively equals that, $500,000. Wouldn't they have to move all that over there?
Correct.
To be protected?
Correct.
So now they don't have it here, and so now what do? Now they're broke?
So as far as the business is concerned, we're going to run the business lean and mean. If there's any cash that's not going to be needed in the next 3-4 months, take the cash out of the business and drop that into your offshore account. If the company has hard assets, I'd recommend selling those, taking the cash, leasing them, and then the excess cash, put that overseas. As far as crypto is concerned, if there's no pending litigation, assign the crypto to the trust, and then the trustee can turn around and hire you as a custodian so you can still hold your keys while they remain under the umbrella of the trust. And then for real estate, if there's only a little bit of equity, it depends on what a little bit is. If it's less than $50,000, I wouldn't put it into the trust. The cost of foreclosure is going to be around maybe $25,000. And before someone does that, you just work something out and settle with them. If there's a few $100,000, then you get a second mortgage and put the proceeds from that mortgage into the offshore account, or put the property at least directly into the trust. That way a court can't order you to hand over the property, and we create more hurdles between a potential plaintiff and your assets. And by doing that, you're giving yourself more room to negotiate.
So you would probably recommend someone call for a consultation if they have a lot of questions, because I'm trying to think them all so while I'm sitting here, but I'm sure there's a million.
Go to blakeharrislaw.com, fill out a contact form, and a member of our team will reach out to you. We've got people working 7 days a week, and we are more than happy to. We don't charge for consultations, and we will walk you through the process. We will give you a recommendation whether or not a trust is appropriate for you. And if so, we would be more than happy to get one set up for you in 30 to 60 days. There's really not anything better that you can do for your peace of mind of your assets than secure it with an asset protection trust, an offshore asset protection trust.
Does anybody use it like a piggy bank? Meaning they set it up and then they just throw 50 grand over there and then 50 grand over there and then 50 grand over there.
Yes. Now, in terms of putting money in or out of the trust, we generally have clients do that maybe once or twice a year. It's up to them. They could take a distribution every day and add money to it every single day. But administratively, it's generally easiest about every 6 months or so to put a big contribution into the trust or take a sizable contribution out.
Well, the thought would be just to keep putting it in, right?
Yes, if we're in a position where personally our assets are growing and we've got more money that we can store into the trust, yes, you can continue to do it, and you can put 50 grand in a month and add to it over time, and that's great.
Or like, let's say, year's good, you make an extra 800 grand, you go buy a piece of property. Should you send the money there and let the trust buy the property, or would you buy the property and then transfer it to the trust?
It doesn't make any difference. You can buy the property directly and then deed the property and then give the property to the trust, or you can give the trustee money and the trustee can buy the property for you.
And no one says, why'd you give a house to that thing?
Well, people may ask why, and your answer is estate planning, asset protection.
So they can't do anything about it, even though they know what you're doing.
Correct. I mean, there are some things that will happen which I'm sure I will upset a few people along the way, especially as more of the planning comes to light, but we don't do anything that gets us in any trouble with the law, that breaks any rules along the way. We just simply take advantage of the laws that are out there.
Now, let's say someone put a bunch over there and they're living lean, because again, if you're smart, you're living lean anyway. And your trusts are making all these kick-ass moves and investments and it's making money. Is that taxable money?
So the trust is a pass-through entity. So if the trust makes money in a way that you would be taxed, it passes through to you. If it loses money, it passes through to you as well. In no way does the trust increase or decrease your tax burden.
So it's not an entity.
Well, it is an entity, but in terms of the way the IRS taxes it, it's a disregarded entity.
Oh, I gotcha. So there's no point in putting $1 million over there and then letting it do all the deals, and all of a sudden it's worth $5 million. And if it is, go ahead. But now you owe tax on that $4 million capital gains.
Exactly. Tax the same way it would be if you did the investments directly through Brad.
What's my other question I had when I first met you? I said, I got questions. I wish this was a live show where I could be like, callers, call in now. Blake will answer your question.
What are the best jurisdictions for setting up an asset protection trust? I mentioned the Cook Islands at first a few times, and that is definitely...
Where are the Cook Islands?
Cook Islands, South Pacific, located halfway between Hawaii and New Zealand. It's its own independent country. It is in free association with New Zealand, but it's its own independent country. It's English speaking. It's a very safe place to do business. It's a very safe place in general. It's not an easy place to get to, and that is an advantage.
Is it a nice place?
Is it a nice place? It is a beautiful place. It's a paradise. It's across the street from Bora Bora. I mean, it is the South Pacific. It's not many more places in the world more beautiful than tiny islands in the middle of the South Pacific.
Are you a citizen when you have a trust there?
You will never become a citizen unless you were born to a Cook Islander. And what's interesting is in the Cook Islands, property rights are based solely on lineage. When your parents die, you inherit the property. When you die, your children inherit the property. There's no way to sell property in the Cook Island. You can lease it out for up to 60 years. But because of this system where every Cook Islander will own property, the younger generation is vested in seeing the government and seeing the country continue to go forward. Compare that to another country, I don't know, the United States, where overwhelmingly millennials, it looks like many of them are not owning homes and will never be able to own homes, and they've lost interest in seeing the system sustain. So the Cook Islands is a very safe place to do business. It's a very safe place to live. It's a very stable country as well. It is not one that gets talked about a lot in politics. I get asked, are the politicians going to pass a law to outlaw offshore trusts? Well, number one, a lot of the people who write the laws or give money to the politicians, they already have an offshore trust, and the rules and the tools out there which protect the wealthy and super wealthy, they tend to stay around. On top of that, the conversation in politics right now is around tariffs or abortion or guns or whatever. Nobody's talking about offshore trusts. It's not an area that comes under any attack or any scrutiny. I will say the changing of the president, I'm not saying from Biden to Trump, but simply changing from one to the next, does give a little boost to the business. Leading up to the election, people get scared. Shortly after the election, people get nervous as well. But the majority of people who end up creating an offshore trust are not politically motivated. They're business minded and want to avoid ending up on the wrong end of a lawsuit.
Yeah. Now, what about Nevis, or as the guy with the lisp says, Nevis?
So Nevis would be my second favorite jurisdiction. Nevis is probably my favorite place that doesn't require you to get on a 10+ hour flight. It has been in the asset protection business since the late 1990s. Cook Islands has been in the business since the mid-1980s. They have a codified bond requirement. They don't allow for Mariva injunctions, which is where you can freeze accounts and freeze the trustee before any litigation commences. Now, Cook Islands, the way we structure it, we do have the flexibility where even if the trustee gets frozen, to move it to another location. I was just meeting with the Prime Minister of Nevis a few months ago, and we were discussing about improvements to the trust legislation. I want to help make the industry as competitive as possible, and the more countries that pass and can stand behind more protective legislation, it actually brings up the industry everywhere. Belize has a great law in place. It's very popular for the zero look back period, but the regulators down there and the government don't instill a lot of confidence. It is just an unstable place to do business. The regulators can ask for information, demand response within 48 hours, and then not respond when the trust companies we work with ask for information back from them for weeks, months, or sometimes ever. So finding the right jurisdiction, it's partially about the laws, but it's also about finding a good government and system that supports it. This is what I love about Switzerland. Not only do they have good banking laws in place, but the entire country is run so well that it just feels like a safer place to do business.
Is there any country that you can put money anonymously left? Used to be Swiss banks, yeah.
It was Switzerland for a while. They had a number of bank accounts. Those days are long behind us. I would say not anywhere that you'd want to put money. I'd imagine maybe Cuba, North Korea, but I wouldn't recommend trying to, number one, do business there because you don't know if you ever get your money back. But even more so than that, that probably gets you added to some list in the U.S. government eyes that you don't want to be on.
Yes. What about Switzerland, though? And I don't want an offshore trust. I just want a Swiss bank account because that sounds cool and James Bondish.
That sounds Wolf of Wall Street. But you can do that. And if you have $1 million, we can get a Swiss account open for you. We have relationships with some firms which will even allow our clients to open up accounts for as little as $500,000, but generally it's about $1 million. And you can do that. You can have access to the Swiss bank, all the benefits we already talked about, the safety, the privacy, excellent, crisp Swiss customer service, but it can still be compromised in the event of a lawsuit. Somebody sues you, the court says, what do you have? You say, I got $1 million in Switzerland. They say, bring it back. You don't have any trustee in there preventing you from bringing the money back. But sure, as an American, you can set up a Swiss bank account.
Has there ever been a case where I call my trustee and say, hey, send me $1 million, and they say no?
Only in the event when you're acting under duress.
How do they know?
Under court order. So it's important that clients communicate with the trustee, and as soon as a client gets sued, the trustee is put on notice. In some circumstances, we just set it up where any request requires the beneficiary, the one requesting the distribution, to swear under penalty of perjury that they are not acting under duress. So you send a request to the trustee, and you include in that request, I swear I'm not acting under penalty of perjury, they'll release the funds. If you send a request and don't make that statement, they're going to ask you to confirm that you're not acting under penalty of perjury. And the that you're not acting under court order, and they need you to swear that under penalty of perjury. And in that case, they won't release the funds unless you can swear that you're not acting under court order. And a U.S. court cannot and will not order you to purge yourself.
How did you get into this?
How did I get into this? This is not an easy area of law to break into. They don't teach offshore trust in law school. Actually, when I was in law school, my trust professor said he would never set up an offshore trust for a client. And so I went by and saw him after class and said, hey, I was actually paying attention today in class, and what is this about not setting up an offshore trust? And he said, well, I wouldn't set it up unless certain criteria are met. And I was like, okay, so in some cases you would. But go ahead and keep teaching all the other law students, don't set up any offshore trust, because I want to go into an industry where there's not a lot of competition. I born and raised in Florida, undergraduate law school, University of Florida Gators. I think there was a basketball game last night. I don't know. Tomorrow, let me see. After I got my law degree, moved out to Denver, Colorado. I was there for about 10 years before relocating down to warm Miami Beach. When I was in Denver, I started my law firm. My law firm was located a few blocks away from another attorney's law office named Barry Engel. Barry Engel was the attorney who drafted the initial Cook Islands Trust legislation back in the 1980s. And he was a great mentor I read his book. I learned a lot from him, and I got some great advice and mentorship along the way. And then as I started to get clients in this business, initially I was partnering with other attorneys who'd been doing this work for a long time. Since then, we've handled clients ourselves. Now, if something comes up that is unique, we do have partners in other places in the world, in the United States, that can help us guide it through. But the real learning curve came to me when I actually went out into the field and started meeting with the trust companies in person. As I said earlier in the podcast, there's a special bond, there's a special level of trust, certain information that you get when you meet with somebody in person and you go by their office in Switzerland, or you go by their office in one of the jurisdictions we do business in. And as I may have mentioned, I've been to close to 50 different countries and done some form of business in lots of them. That's where it really took off. On top of that, having built up a very strong marketing team, we've brought in lots of clients, and by bringing in lots of clients, we've done lots of work, which has gained us lots of experience, which then in turn has made it easier to continue to grow the business from there. It's been something that has taken my full life and career and dedication for the past 10 years. Other than 1 week last year, I'd never taken off in a single day for the past 10 years. It is a business where your phone rings all hours of the day because you're working with people from all over the world. I say the sun never sleeps on the offshore industry, and that's very much true. It's one in which speed is very important. I've got my team trained where if you contact us, you're going to hear back from us very quickly. If you send us paperwork, we process it and we move it along very quickly. Speed is very important. It's important not just to get everything set up properly, but also to show the clients that they are working with a firm that has this business down to a science.
Well, I think you represent that. Is there any ongoing fees to maintain it?
There are ongoing fees to maintain it. So it's around, I say about $5,000 to $10,000 a year to maintain the trust. That covers the annual fee for the trust company, which may be around $3,000 to $5,000. That covers the protector fee, maybe $1,000 to $2,000 on top of that. On top of that, your law firm is probably going to charge an annual fee of $1,000 to $2,000 to serve as your ongoing advisor going forward. And then on top of that, the tax reporting requirements is going to be another around $2,000.
And what if you want advice, or, I want to talk to someone and think things through? Like, is it just like normal attorney fees per hour? Or?
Not with my law firm. We do not do any hourly billing. Just the opposite. We do everything on a flat fee because we want to encourage clients to communicate with us. When clients are afraid to communicate with their advisor, they start guessing what they're supposed to do, and that's when things go wrong. We do everything on a flat fee. We don't bill for calls or emails. If clients are communicating with us, we can walk them through the process and get everything set up for them in a way that we can keep our record of having never once had a penny taken out of a trust.
Boom. Folks, there you have it. Don't say I never did nothing for you, especially you Richies that are watching. But I wouldn't always just recommend the Richies get a hold of Blake. I would say anybody who's intending to be, or just doesn't want to lose what you've already got, and you can grow it, you can protect it. And if you have any questions, just reach out to Blake, because obviously he seems to be the expert here.
Thank you very much. It's all about peace of mind. We protect assets, and that is something that you do see the long-term benefit of in time. But the moment you've got the trust set up, the moment you start starting the process, I've had clients just give a sigh of relief, and that feels so good to me. The best thing I hear, and just had this call recently from a client who many years ago set up a trust, got sued very shortly after, finally everything resolved. And he said, Blake, the trust worked exactly as you said it would. And that feels good. And that's why I keep doing what I'm doing.
And you already said earlier, it's not a matter of if you're going to get sued, it's when.
If you're successful, then it's in the United States, a lawsuit is a badge of success.
Yeah, it's 100%, and the higher you climb, unfortunately, the bigger of caliber they have to shoot at you.
Oh yeah, the bigger the empire, the more opportunities for attack.
Yeah, so folks, all my entrepreneurs, I'm telling you, reach out. I just found you the best dude on the planet for this. Blake Harris, attorney, Blake Harris Law. No, it's just BlakeHarrisLaw.com, but that is attorney Blake Harris. What can the Bomb Squad do for you?
What can the Bomb Squad do for me?
Yes.
The Bomb Squad.
That's the listeners.
That's the listeners. What can the listeners do? What can the listeners do for me? Hey, it's your money. Start acting like it. If you have questions on asset protection, feel free to send them my way. Happy to guide you in the right place. If you want to read more on the subject, I have written a book, Don't Let a Lawsuit Take Away Everything. Happy to share a copy of the book. If you have a podcast as well and would like someone to discuss offshore asset protection, their travel, and come dressed up very nicely, feel free to reach out. And I'll just say it again. It's your money. Start acting like it.
Boom. There you go, guys. Till next time, keep it safe and keep it real.